Thank you. Good evening, everyone. My name is Paul Cadigan. I'm chairman of the Kennebunkport Zoning Board of Appeals. This is a virtual zoning board of appeals meeting. We're using the Zoom conference format. The agenda is on the town's website and that has the information needed for the public to participate by Zoom conferencing or by telephone. If you wish to participate in Zoom, you can join Zoom meeting, and the number that you need to do that is 955-1101-6680. You can also dial in by phone. On the East Coast, the number you dial is 929-205-6099, or in the rest of the United States, you can dial 301-715-8592. You will be asked to enter the meeting ID number. Again, that meeting ID number is 955-1101-6680, and follow that by hitting the pound sign. If you are conferencing in by telephone or through Zoom and watching this on cable or YouTube, you must turn down the volume on your cable or YouTube, or we'll have feedback from your participation. As always, you can watch television on channel 1301, or you can stream us on YouTube at Kennebunkport Television. This meeting, only the Zoning Board of Appeals members and the current participant, as selected by the board, will be on screen with audio connected. All other participants will be black and audio muted, except when the board solicits public input. I ask that the public take turns when talking. Allow others an opportunity to talk once you have made your point, and make sure that you identify yourself prior to beginning talking. We appreciate your support and patience as we rework our public meeting process to allow public input while we carry on necessary town business. So at this time, I'm going to take a roll call for the zoning board. And Karen, if you could note these as we go along. First, Karen Schlegel, here.
Here.
April Defoe, here.
Here.
Kevin McDonald, here.
Here.
Jim Fitzgerald, here.
Here.
Gordon Ayer, here.
Here.
Wayne Fessenden, here.
Here.
And I'm Paul Cadigan. I'm here as well. We have a full board meeting, 7 members. And so we clearly have a quorum as well. David, do you want to explain anything to the audience with regard to process and controls before I proceed further? Thanks, David. The process for engaging the applicant, the code office, and interested parties will be as follows. This is going to be kind of deliberate. After I've introduced the agenda item, I will request that the applicant and or his representative to raise their virtual hands. I will acknowledge them and ask for David to promote them from panelists so that they will be visible to the board. Once they have been promoted to panelists, I will direct them to proceed. After the applicant has presented their case, I will call upon each board member individually to give them the opportunity to ask questions of the applicant. Once the applicant and the board have completed this process, I will direct David to place the applicant back into the audience. I will repeat the process for the representative of the Code Enforcement Office. I will ask them to raise their hand, their virtual hand, and ask for David to promote them to panelists. and allow them to present their case. I will call upon each board member individually to give them the opportunity to ask questions of the code enforcement officer. Once the code enforcement office and the board have completed this process, I'll direct David to place the code enforcement office back into the audience. I will then repeat the process for the representatives of 200 Ocean Ave. I will ask them to raise their virtual hand and ask for David to promote them to panelists and allow them to present their case. I will call upon each board member individually to give them an opportunity to ask questions of 200 Ocean Avenue representatives. Once that has occurred and the board has completed the process, I will direct David to place 200 Ocean Ave back into the audience. Two more groups. I will repeat the process for abutters to 200 Ocean Ave. Now, if any of the abutters to 200 Ocean Ave wish to participate, I'll ask them to raise their virtual hands and ask for David to promote them to panelists and allow them to present their case or make their point. I will call on each board member individually to give them an opportunity to ask questions of any of the abutters. Once the abutters and the board have completed that process, I'll have the abutters, I'll ask David to place the abutters back into the audience. So that's after the abutters. Then I will repeat the process again for the general public. And I will ask them to raise their virtual hands and ask for David to promote them to panelists and allow them to make their point or present their case. I will call upon each board member individually to give them an opportunity to ask questions of the general public that have spoken. Once the general public and the board has completed this process, I'll direct David to place the general public back into the audience. All the input has been given to the board. I will close the hearing. Now, I will try prior to that time to see if there is any rebuttal that is being requested of the party. The party being the representatives of Mr. Slager, the representatives of the owners of 200 Ocean Ave, and the representatives of the code office. We'll try to work through that process as well. Thereafter, I will close the public hearing and that portion of the appeal and invite the board to begin their deliberation. I will call upon each board member individually for this. Should the board need any additional clarification of any of the interested parties, I'll ask David to promote the party to panel and allow that clarification to be completed and then place that party back into the audience. Once the board has completed its deliberations, I will ask for a motion. I will repeat who has made the motion, who has seconded the motion. I will then call upon each board member individually to register their response to the motion, to vote on the motion. This is how we're going to go through. Now we have two appeals this evening. So then we will repeat the process that I just walked you through for the second appeal. Both appeals are by the same appellant, and the parties involved are the same parties. So I'm first going to just simply introduce the first matter on our agenda, and it appears as follows. Number one, item number one, Randy Slager, applicant. Now the submission date was December 27th, 2019. The applicant is appealing the lifting of suspension of permit in violation of subsection 11(5)(c). This regards 200 Ocean Avenue, which is tax map 7, block 12, lot 5 in the Cape Arundel zone. Now, the purpose of this hearing is to determine if the zoning board of appeals has jurisdiction to hear the appeal under the land use ordinance, and in particular, section 9(2)(a)(1) and sub 2. That's the first item on the agenda. I'd like to make a note for the record that our ordinance requires that after the application has been filed, board has a 35-day period to first schedule a hearing on that matter. There is a provision in the ordinance, and that is section 9(3), I believe it's D. 9(3)D, which says that that 35-day period can be extended if by agreement of the parties. In this circumstance, on this appeal, as well as in the next appeal, the parties agreed to extend the period of time, and that brings us to this hearing this evening. I'm getting a little feedback. I don't know if anybody else can hear that as well, but I'll continue. So first, before moving into the process of actually hearing the matter, I have one housekeeping matter to take care of. And that regards myself and my relationship with the applicant. As any of you will recall, Mr. Slager had a prior appeal brought before the zoning board. At that time, I recused myself from participation in that matter because the subject matter of that appeal was something that Mr. Slager had come and consulted with me on. I did not accept payment from Mr. Slager. Our communications were rather brief, but there were a couple of them. So I thought it appropriate that I recuse myself. With regard to the two matters pending this evening, I personally believe that I don't have a conflict of interest. The subject matter of both appeals has to do with action by the code enforcement officer that occurred after any communication that I had with Mr. Slager, after the first appeal of Mr. Slager, after Mr. Slager hired the attorneys that now represent him. And so I feel that I have no conflict with regard to hearing the matter of whether or not these two appeals, if the board has jurisdiction to hear them. So again, according to, I think it's best by statute, it's appropriate for this board to vote upon whether or not the board feels that they have a conflict of interest, which would require me to stand down from conducting these hearings. I'm not going to vote on any motion or discussion with regard to the board's thoughts on whether or not I have a conflict. I'm saying I don't believe I do, but that's really a decision for the board to make. So Wayne, can you hear me?
Yes.
Thank you. So as Vice Chair Wayne, could you organize a vote on the subject matter of whether or not the board believes that I have a need to recuse myself from conducting these hearings?
Can we start with a motion, please, from someone, and then we'll have a discussion?
Yeah, this is Kevin. I'll make a motion. So I make a motion that we allow Paul Cadigan to continue to hear the matters before the Zoning Board of Appeals this evening based on the information that he just provided to us.
Have a second?
I'll second.
Discussion. Are we going to open this up to the two separate parties
Well,
for
it's
their
not-
opinions?
It's a decision.
It's a board
of the
decision.
board. It's a board
Yeah,
decision.
Okay. No further discussion? Let's take a vote. Then, Jim, you're muted.
I'm really not,
Ah,
but I am, I vote yes.
Gordon,
Yes.
Kevin,
Yes.
April,
Yes,
Karen,
Yes.
and myself, yes.
Okay, so thank you, and let the record reflect that, Karen, please.
Mhm.
So I'm going to again remind the participants, the parties, that we are going to attempt to get in rebuttal time for each. We'll reserve, because of the format that we have, we'll reserve rebuttal time after everybody has made their presentation. and I'm going to ask that everybody try to keep any rebuttal time short. Now, before I bring up the representative for Mr. Slager from the audience to panelists for the arguments to be presented, I would like to make note that the board members have each received a memorandum from Attorney Lowry, a memorandum from Attorney Rosenthal, and a memorandum from Attorney Shaw, all of which are somewhat detailed, were provided, I believe, in timely fashion, one and all, to the board. The board has had an opportunity to review all of those. So it's my request to the representatives of the party that they not reiterate everything that they have submitted in their memorandums. And it's also my very specific request that the parties focus their presentation singularly on the issue before the board, which is whether or not the board has jurisdiction to decide this appeal. That's the sole purpose of the hearing this evening. So having said that, I'm going to ask if David or Michelle would bring up Attorney Lowry from attendees.
Paul, excuse me, second.
Go ahead.
How about if we have everybody on the panel mute their mics and you keep talking and let's see where the feedback's coming from, because it's very annoying.
Okay, well, I'm open to that suggestion. Go ahead.
Leave yours open and let's everybody close out.
Okay, Gordon, the mic's still open.
We don't know how to.
Okay. Well, there's no feedback now. Do you want to bring them back one at a time and see if that's where the feedback's coming from?
That's a good idea. It sounds like it's Gordon.
Okay. Bring back one more. I think it's coming from Gordon. Do you have anything on in the background at all?
No. Yeah,
Nothing.
there's nothing.
Yeah, that's where it's coming from.
There's nothing on.
Yeah, there's nothing.
It's just his voice feedback. He's his mic is picking us up talking.
I have no idea how to address that.
Can I turn the volume?
Okay, do you mind doing that, Gordon? Just when you're going to speak, unmute yourself, but prior to that, keep yourself on mute because we're getting a feedback over your line.
Hold on, Susan's.
Yep. Okay.
There is an easier way. You can just hit the space bar when you want to talk. Even if you're muted, the space bar will unmute you.
Okay, we're gonna mute. How come it's- Oops. Whoops. Okay,
Yeah,
that works.
okay, fine.
Okay. Did we lose somebody? No.
Do we all want to be unmuted?
Yeah, we can all come unmuted. We'll leave Gordon muted just until, Gordon, when you want to speak, just give us a hand and we'll get your mic back on. It's the only way to address the feedback, I guess. Okay, so if everybody is okay with that and we're moving forward, then could you please bring up Attorney Lowry, David Lowry, so he can address the board as to the argument he'd like to make on why the board has jurisdiction to hear this first appeal. David, are you there? Okay.
Okay. Yeah, well, best you're gonna get, I'm afraid.
Oh, there's all of you, David.
Well, most of me. Seriously, we've been having a problem here. We got cut off a little while ago, and now we're running on a hotspot because the Wi-Fi here has failed. So hopefully we'll be able to keep going. I just wanted to warn you in advance that if we suddenly disappear, it's technical errors, and I didn't hang up on you.
Okay, so David, you've got the floor at this time to present your case. I don't know if you heard me, but I was asking that we've all reviewed the materials you've submitted. And so I'm hoping that you won't find the need to repeat all of the materials you've submitted, and that you focus your presentation solely on the issue of whether or not the zoning board has the jurisdiction to hear this appeal.
I will try to be focused on that issue. Okay. May it please the board. I've been appearing before or advising boards of appeals for almost 50 years, and I'm under no illusion that a board will find jurisdiction where its usual counsel, the person who regularly and properly, the person that they regularly and properly rely on for legal advice has given them an opinion to the contrary. So I'm going to direct a lot of my attention to what Amy Chow said in her filing. And I want first to direct your attention to the fact that Amy is not acting as the board's attorney on this occasion. She's made it very clear that she's representing the CLE Gilliam tonight, at least on this issue. And she's, because she's recognized that she can act as both an advocate and an advisor to the board. And having chosen not to bring in outside counsel, her opinions and what she expressed is on a par with my opinions and those of Attorney Rosenthal. We're all advocates before the board. As I said before, CEO Gilliam does not want you to address the merits of these appeals, and Amy's filing reflects her client's position. Turning to the three arguments advanced in Amy Chow's advocacy memorandum, her first point is the board is not free to choose whether to take jurisdiction or to decline jurisdiction. I expect that all the lawyers present can agree to that, as well as the board members. Obviously, you're not free to choose. In our opinion, you have to decide whether you're going to obey your code section 9.2, which seems to, it was pretty clearly intended to prevent you hearing a matter like this. However, you have to, that section has to be consistent with state law. Unless you can reconcile the two provisions 100%, if they're in conflict, you're going to have to go with the state statute, which is section 4353. I think everyone there has seen a copy of it. If you've got my memorandum, it's in footnote number 2. It's hard to read because I put it in small print. I should have made it in bold capitals. And if anybody has any questions about that, I will read it to you, but in the interest of moving along here, I'm not going to do that this time anyway. So the answer to your jurisdiction has to be found by comparing Title 30A, Section 4353, which requires you to exercise jurisdiction on any appeal brought from the code officer, unless the land use law provides for a direct appeal to the Superior Court, in which case you're bypassed. But the general rule is that you have jurisdiction unless they have provided in section 9.2, because it says it has to be in the ordinance. It doesn't necessarily have to be in 9.2, but it has to be somewhere in the ordinance, and I couldn't find it. A provision which expressly provides for a direct appeal to the Superior Court. Basically, what the way it was drafted is very poor, because it's not just a matter of creating confusion and forcing us to file both with you and with the Superior Court in order to protect Mr. Slager's interest. It's not just badly drafted, and it's not just a technical problem. It's a problem of jurisdiction, and this is a central question: jurisdiction. Is the unless provision met? If it's not met, then you clearly have jurisdiction and have to hear this appeal. If in fact, and I'm not saying intent, I mean, it's not a question of intent on the part of the drafters of that ordinance. Their intent is pretty clear, to preclude us coming here with an enforcement related matter. But you can't give that ordinance effect if it's in violation of state law. And it pretty clearly is, because you can search through there. You can search through 9.2 over and over again, and you're not going to find a mention of a direct appeal to the Superior Court. It says it has to provide that you can only take a direct appeal to the Superior Court. In fact, what it says, most unfortunately, it says any notice of violation or any order, requirement, or decision or determination made by, or failure to act in the enforcement of this ordinance is not appealable to the Board of Appeals. Then it goes on to say such enforcement actions are appealable only to the courts as allowed by law and the rules of civil procedure. So what actually happens here is that the ordinance tolerates other appeals. It doesn't say, and it tolerates existing appeal language somewhere else. It doesn't say that you can only go directly to the Superior Court, which is what the statute requires it to do and to say. It has to be in the ordinance and has to make the exclusive way that you go to the Superior Court by direct appeal, which is not the normal provision. Normally, they go to you before they go to the Superior Court. And the law court has repeatedly ruled that any doubt as to whether a Board of Appeals has jurisdiction of land use and code matters must be exercised in favor of the board jurisdiction because of the wording of section 4353, and because, and you can find this in my memorandum, there is a strong public policy disfavoring direct appeals to the Superior Court. They want you guys to hear it first and make a decision, which they can then review. And that's the way Rule 80B works. Obviously, the town or whoever drafted this provision wanted
David, I don't know if you can hear me, but your feed has frozen. David, can you hear me?
to bypass you from the Superior Court if you decide that you don't have jurisdiction. The use of the exception, it's all built into one sentence in 4353. It says, the Board of Appeals shall hear appeals from any decision or failure to act of the official or board responsible for enforcing the zoning ordinance unless only a direct appeal to the Superior Court has been provided by municipal ordinance. In fact, 9.2 says such enforcement actions are appealable only to the courts as allowed by law and rules of civil procedure. So this doesn't create a right of appeal, of direct appeal to the Superior Court, which is what the statute says you got to do if you're going to oust or divest the Board of Appeals from their usual jurisdiction. So, as I'm saying, section 9.2's attempt to carve out certain CEO decisions involving violations of the land use code and building code from your statutory jurisdiction cannot be given effect by you and will not be given effect by the courts, where section 9.2 doesn't meet the statutory requirements. I don't want to repeat what I've given you in writing already, so let me skip through here for a second here. Anyway, statutory compliance in this case is not a technicality. It's a condition precedent to your being ousted from jurisdiction, which is clearly the intent of the ordinance, but you can't give effect. That's what word I was looking for. You can't give effect to that intention. It's not a matter of intention here, which is one of Amy's attorney Chow's points. Yes, they intended to oust you from jurisdiction over such things, but they didn't effectively do so. I'm not feigning court venue confusion. I understand I believe I understand the situation. We filed both with you and with the Superior Court in order to protect Mr. Slager's rights, because he needs to have a right of appeal. That's in the main Constitution, because the code officer is an executive officer and it would violate the separation of powers clause of the state constitution if he had final decision-making power. It has to be reviewable by a court, either through you or directly to court, one way or the other. So the bottom line is that you have to decide whether the first part of the first sentence applies in section 4353, or the second part of section 4353 applies. And you can only do that, you can only make that decision by looking at the ordinance as it was adopted to see whether it provides only for an appeal directly to the Superior Court. It clearly doesn't. It talks about other courts. It doesn't say other courts, sorry. It says you can have whatever, you can continue to have whatever you got when this ordinance was passed. The courts, you can figure out for yourself whether you're supposed to be in the Superior Court or be in the law court or someplace else. In any case, confusion is not really the issue here. The issue is whether there is statutory compliance, which is a condition precedent to ousting you of jurisdiction. So the bottom line is you have jurisdiction unless they complied with the statute in writing section 9.2. They didn't comply with the statute in writing section 9.2. Their intent to oust you from jurisdiction is pretty clear, but you can't give it effect because they didn't comply with the statute. The statute always beats an ordinance. I think even Mr. Rosenthal will have to concede that. And the bottom line is, and hopefully Amy will tell you that, the bottom line is if you don't hear it now, you'll have to hear it later when it's remanded by the Superior Court. That's short enough?
That's wonderful. Thank you. So now if you'll stay with us, David, where I'm going to ask any of the board members to, one by one, to see if they have any questions of you. So I'm going to start with Jim Fitzgerald. Do you have any questions of Attorney Laurie?
The only question I have is, what difference does it make when the time actually ran out for appeal? And it seems that many, many days went by without an appeal even being asked for.
I'm sorry, I think we're clearly timely. I don't know what you're talking about. We had 30 days to appeal to you as well as to the court, and we did both.
Well, then I don't have any questions. Thank you.
Oh, sorry, were you referring back to the first appeal? This appeal is focused on what was done under the permits, pursuant to the permits they got, not whether the permits were originally granted properly or not.
Okay.
So I'm sorry, I misunderstood.
Anything else, Jim?
All set. Thank you.
April, do you have any questions of Attorney Laurie?
I don't think so.
Okay,
Not at this, anyway.
okay, we can come back. Karen, do you have any questions?
No questions.
Gordon, any questions of Attorney Laurie? Wait, hold it, Gordon. Gordon, audio, can we turn you on? Phil, can you turn him on? Go ahead.
How's
Gordon.
that?
Good, go ahead.
So David, for the fourth time, I want to compliment you on your explanation because it's a very tricky subject and you've made it very clear. Thank you.
Any questions, Gordon, or just that?
No questions.
Kevin, do you have any questions?
Just one. So I want to understand the premise. So in 9.2A1, it, drives the zoning board of appeals. It says such enforcement actions are appealable only to the courts as allowable by law and the rules of civil procedure. So I think the premise of your discussion is the fact that the word superior is missing from that reference to courts in 9.2A1, is that right?
No, because that section of 4353 is not self-executing. It's got to be adopted as part of the ordinance, the unless provided, a direct appeal is provided for. The state statute is only operative once the municipality, that portion of the state statute only operates when the municipality enacts an ordinance which applies, which only permits direct appeal to the Superior Court. And that's not what the ordinance says. The ordinance is sort of all over the place. And it was obviously written by a layperson or else somebody who wanted to confuse the issue, one or the other, because it's not consistent with the statute. And to the extent it's not consistent with the statute, the ordinance doesn't provide the condition precedent for a direct Superior Court review. And therefore, the default provision in section 4353 applies. That is that you have jurisdiction. It says you're supposed to hear all these cases. And then they provided for an exception. If the municipality has provided that the only, in the ordinance, has provided in the ordinance for the only appeal you have is a direct appeal to the Superior Court. Well, they haven't done that. They say you can go wherever you want if it's allowed by law, if it's otherwise allowed by law or the rules of civil procedure. And that's not good enough.
Okay, thank you.
You're welcome.
David, I have a question. On that language in 9.2.1, where it says appealable only to the courts as allowed by law and the rules of civil procedure. I want to ask about the rules of civil procedure. If in the circumstances here where you want to appeal an enforcement action by the code enforcement officer, don't the rules of civil procedure direct that you need to file that action in Superior Court? Isn't that a mandatory element of Rule 80B?
Well, Rule 80B is a rule for reviewing decisions which have already been taken or failed to be taken. Rule 80B doesn't allow you to proceed, or doesn't, how to put it, you have other ways of going to court, as you well know. You can go for a declaratory judgment, or you can go on some other theory other than an appeal. But you can only appeal from decisions under Rule 80B. Maybe I'm not understanding the question, because Rule 80B doesn't deal with what happens between the code officer and the Board of Appeals, except to the extent that a final decision is rendered by somebody that's then reviewable by the courts. So maybe you can explain to me again what your question was, because I'm not understanding it.
Well, I know you said that in your presentation, you said that a decision of the code enforcement officer, we'll say in the town of Kennebunkport, can't be a final, it has to be appealable. And so.
No, I said it can't be constitutionally non-appealable.
Right.
It has
So
to be.
I agree. It needs to be appealable. And does Rule 80B in the main rules of civil procedure pertain to any court in the state of Maine other than the Maine Superior Court?
Rule 80B does not, no.
It only pertains to actions on appeal in the Superior Court, correct?
Rule 80B isn't mentioned in section 9.2 either.
No, it is not. But what's referenced in, well, thank you for the answer. But you're agreeing with me that Rule 80B directs that appeals that are governed by Rule 80B of the main rules of civil procedure go to Superior Court, not District Court, not Probate Court, not the Supreme Court. They go to Superior Court.
No doubt about that. But I'm saying it's not only inconsistent with the statute, it's also vague. There are enough traps for the unwary in Rule 80B as a practical matter without creating a new one through this ordinance.
Okay, thank you. Does anybody else have any follow-up question for Attorney Lowry? Okay, so David, what I'm going to do is have you go back into the attendees pool, and then we're going to bring forward Amy to make her presentation with regard to the code enforcement position.
Thank you.
Thank you. So if you would put David back in the attendees, and if you would be so kind as to bring up Amy Chow to Attorney Chow to present the code enforcement officer's position.
Hello there.
Amy, you have the floor.
Thank you, Mr. Chairman, members of the board. I'm Amy Chow, and I wanted to address and underscore who I represent here tonight. Mr. Laurie is correct that I am here in my capacity representing the Code Enforcement Office, and the main officer is Werner Gilliam. In this matter, I do not purport to represent the board in this proceeding, and so I agree that my position before the board is of advocating the position of the Code Enforcement Office with respect to jurisdiction of the board this evening on this matter. I wanted to focus, since Mr. Laurie focused on what the law says, I wanted to focus on exactly where the Board of Appeals jurisdiction comes from, and then go straight into 9.2A1, if you will allow me to. And I'm basically going to be summarizing starting on page 3 of my memo to the board. So the Board of Appeals, I will agree with Mr. Laurie that the Board of Appeals is a body that is a body of limited jurisdiction. And what I mean by that is it derives its authority from two central places, a combination of statute and local law, which can be ordinance provisions or charters. Now, Kennebunkport does not have a charter. It does have an administrative code. But basically, in terms of looking at what authority and what jurisdiction the Board of Appeals has, we're looking at those two things, state law and what does the ordinance say. And apart from what state law and the ordinance says, the law has been very clear in Maine that boards of appeals are bodies of limited jurisdiction, which means that you cannot exercise jurisdiction over matters that are not expressly conferred upon you to decide. So, for example, state law under section 4353 does give you the authority to hear variance appeals. We all know that. That's also in your ordinance. That's not why we're here tonight. But state law also, there's a section that Mr. Laurie did focus on, but he neglected to focus on another statute that I think is just as important and places things into context when you look at 9.2A1. So I agree that section 4353 says basically, hey, if you're a town and you have an ordinance, you must have a board of appeals and you must abide by certain provisions in the statute, and that's in 4353. And it is true that 4353 sort of adopts a general rule that enforcement decisions regarding a zoning ordinance are generally taken up by the Board of Appeals unless, and we are arguing about what the unless language means, that except if a town decides that the appeal should go directly to court and bypass the Board of Appeals. Before we get into 4353, though, I think it's very important for the board to focus on the other statute that is very clear, and that is Title 38 MRS Section 2691. And that is the section that actually is the longest section in the statutes that governs the Board of, how the Board of Appeals follows certain procedures, and also goes to questions of what matters the board has the authority to hear. And the section that I think the board needs to focus on here, I think Mr. Laurie has only given half of the equation. Section 2691 sub 4, and I'm just going to read it, it's in my memo, but it says this: no Board of Appeals may assert jurisdiction over any matter unless the municipality has by charter or ordinance specified the precise subject matter that may be appealed to the board and the official or officials whose action or non-action may be appealed to the board. So pausing, that section right off the bat says these statutes say, even though there might be some general rule saying that boards of appeals can hear enforcement matters, and certainly there are boards of appeals across the state that do, that a municipality like Kennebunkport, just as Kennebunkport has done in this very case in 9.2A1, has the authority, says the statute, to decide what matters should be heard by the Board of Appeals and what matters should not. And so that is the section, I believe, that is that you should hold foremost in your mind as you head into looking at the plain language of section 9.2A1. Okay, and so before we go into 9.2A1, I would also like to point out another amendment to section 2691 sub 4 of Title 30A, and it's in the very next indented paragraph on page 3 of my memo. And this was an amendment in 2013, and it's an amendment that again recognized the idea that a Board of Appeals could hear whether or not the code enforcement officer should have issued a notice of violation or should not have issued a notice of violation, or should have taken enforcement action or should have not. Okay, and so this is an issue that the law court has talked about and decided, should boards of appeals look at this stuff? Because isn't what a board of appeals doing when it is second guessing an enforcement decision, isn't that like issuing an advisory opinion? Hey, you shouldn't have enforced the ordinance this way, Warner, or you should have issued a notice of violation, Warner. Okay, and so let me just read what it says, because the italicized language I think is very important in context here. It says, absent an express provision in a charter or ordinance that certain decisions of its code enforcement officer or board of appeals are only advisory and may not be appealed. It then goes on to say a notice of violation or enforcement order by a code enforcement officer under a land use ordinance is reviewable on appeal by the Board of Appeals and in turn by the Superior Court under Rule 80B. And I will note and underscore that I agree with Chairman Cadigan's point that there is no doubt that any decision that is a final decision, whether it is made by the code officer or the Board of Appeals or some other town official, the appeal of that decision is clearly to Superior under Rule 80B, and there is no confusion as to which court that should be in. But if you look at the italicized language, again, this language in 2013 amended the ordinance, the statute governing boards of appeals to say, hey folks, an ordinance can decide that certain decisions of a code enforcement officer may not be appealed to the Board of Appeals. That is within the municipality's right to do so. And that's exactly what 9.2A1 does. So if you'll oblige me and go to page 4 of my memo, which does in totality describe and reproduce what 9.2A1 says, and I will not read it all to you. But if you look at the plain language of 9.2A1, I would submit to the board that 9.2A1 does exactly what the statute in 2691-4 allows a municipality to do in cabining the Board of Appeals jurisdiction with respect to certain code enforcement officer decisions. And they are as follows. It has said that a decision by the code enforcement officer in his or her review of an action on a permit application, that goes to the Board of Appeals. Clear as day, it clearly goes to the Board of Appeals, and the Board of Appeals can modify or even reverse that decision. It goes on to say, though, that any action or decision by the code enforcement officer in the enforcement of this ordinance is not appealable to the Board of Appeals. That is exactly what the language in 2691-4 allows a municipality to do. It has clearly done so. And Mr. Laurie's undue focus, I would submit, on this 4353 exception language omits an interpretation of this ordinance language in light of what 2691, the statute, says a municipality can do. It's saying, guess what, folks? We actually don't want to have the Board of Appeals wasting its time on enforcement-related decisions, on second-guessing a code enforcement officer's enforcement-related decisions once the permit has already been issued. We certainly, as the main interpreters, I'm talking about, when I say we, I mean you as the board, we certainly are charged with interpreting the ordinance, right? 9.2A2 specifically gives the Board of Appeals the authority to determine the meaning of the ordinance, especially where the meaning or intent of any part of that ordinance is uncertain. That's within your power to do. And I would suggest that the language here could not be clearer, that a decision to lift a suspension on a permit and a decision to suspend a permit for reasons because the permit holder may not have been complying with that permit is precisely the enforcement related type of matter that this section, Kennebunkport has decided, should not be reviewed by the Board of Appeals. It really should go to a court. And that's exactly what this says. And I think Mr. Laurie's argument under 4353 places too much weight on that statute and is a very technical argument, I would submit. This is not an intent argument that I'm making. It's an argument based on the plain language of 9.2A1. And when you read the plain language of 9.2A1, I think it's crystal clear that enforcement-related actions are appealable. They are appealable to the courts. I would agree that it does not say Superior Court, and it does, 4353 doesn't say it has to say in the ordinance language itself that it is, that the review is to the Superior Court as opposed to the District Court. So I think it's clear. Just one more point on this piece, if I could, is that the argument goes a little bit too far. Mr. Laurie is saying, well, because it doesn't say Superior Court, how do we know it's not District Court? First of all, Mr. Laurie had no confusion because he did submit an actual ADB appeal in Superior Court for this precise matter. And I would suggest that there was no confusion about that. Had there been any confusion, that doesn't suddenly spring jurisdiction into the board's hands. In other words, if this language said, hey, your appeal is to the courts and not to the Board of Appeals, and it should have said Superior Court instead of District Court, but it just said courts, that doesn't mean the default is that suddenly the Board of Appeals has jurisdiction. That makes no sense. So I think when you look at the entirety of the plain language of 9.2A1, and you look at your authority to interpret your own ordinance under 9.2A2, and you look at all of that in the context of the statute 2691 and even 4353, I think it's crystal clear that the board here does not have jurisdiction over these two matters that deal with the lifting of a suspension of a permit. Thank you.
Thank you. Now I want to see if any of the board members have questions. Jim, I'm going to start with you. Any questions of Attorney Chow?
Very clear. Thank you very much.
April?
Nope, I'm pretty clear about what Amy had to say. I don't think I have any questions yet.
Karen Schlegel?
No questions.
Okay. Wayne?
Yes, Amy, 92A2. Where the uncertainty and the intent of this ordinance, are you presenting that we don't try to interpret the statute, which appears to be above the ordinance, above an ordinance?
I think your charge under 9.2A2 is to interpret your ordinance where you find that there is uncertainty in your ordinance. If you need to interpret a statute in order to make an uncertainty in your ordinance more clear, then you can do so. But I would submit that there is no uncertainty in your ordinance. 9.2A1 is crystal clear. That the appeal on an enforcement-related matter such as this, which I will also underscore that Mr. Laurie has already stated to the court in his ADB appeal that the appeal is to court and is to the Superior Court and not to the Board of Appeals. But I think 9.2A1 is clear. And so there is no uncertainty requiring you to look at 4353 and say that that trumps the clear language of 9.2.
Thank you.
Gordon, any questions for Amy?
No question.
Kevin?
No questions.
And I have no questions either. Thank you, Amy.
Thank you very much.
David, if you could put Amy back as an attendee. And now we'll hear the representative for 200 Ocean Ave, which I think is going to be Dan Rosenthal? Thank you. You there, Dan?
I am here. Can you hear me?
We can hear you. So you've heard the arguments that have been presented so far, and you know we're trying to stay focused on the particular issue at hand, so the floor is yours.
Thank you very much, Chair Cadigan, and I want to just thank all the members of the board for allowing me to appear on behalf of Lori Bell and John Scannell, who are the owners of the property at 200 Ocean Avenue. I'm going to try very hard to not only avoid repeating everything that's in my written submissions, but also to avoid repeating the points that Amy Chow has made so well. We, I think, make many of the same points, and I would like to repeat everything that Amy just said, but out of respect for the board members' time, I'm going to try not to do that. It's not for a lack of conviction or belief in our position, but I don't think that you need to hear it all again from me.
Thank you.
Let me just try to touch on a couple of things. I don't think there's any real question, but that what the code enforcement officer decided in early December and then in late February was enforcement. He had suspended permits. He then lifted the suspension, reimposed it, lifted it again rather. Those are enforcement decisions. And I think I heard Mr. Laurie say earlier in response to Mr. Fitzgerald's question that the appeals here don't relate back to the permit application. They relate to what the code enforcement officer did in suspending permits and then lifting the suspension. And I agree with that. The permit was issued back in December of 2018. There was never a timely appeal from it. And we're not talking here about permit applications. We're talking about enforcement. I agree with Amy Chow that the ordinance is very clear. It says that appeals from enforcement matters go to the courts. It specifically refers to the main rules of civil procedure, which Chair Cadigan has pointed out, point the appealing party directly in Rule 80B to the Superior Court. So I don't think there's any question about an ambiguity there. The legislature has said that the town has the right and the power to arrange things this way, and that is what the town has done. It's not all over the place in any respect. It's very clear. And as Amy mentioned, the statute, section 4353, doesn't say that a municipality has to use certain magic words to provide that appeals go to Superior Court. It just says that an ordinance can provide that only a direct appeal to Superior Court is provided. And so the question for you is just reading the ordinance and asking, does this ordinance say that you can only go to Superior Court on an enforcement matter? And it does. That's what it says. It says that you go to court under the rules of civil procedure, and those rules take you to Superior Court. It's a straight line. And so I don't think anybody is saying here, I'm certainly not saying that the ordinance somehow trumps the statute. That's not the case at all. The ordinance does what the statute allows it to do. It points you in a straight line to the Superior Court. And so that's where this appeal belongs. And I would just reiterate, as Amy said, that when Mr. Slager appealed to the Superior Court, he said that his appeal was of an enforcement matter, and that's what the basis for his appeal to the Superior Court is. Even his own appeal, in this case, his appeals don't say that this is about a permit application. They don't say that this is about some kind of an amendment to the permit application. The fact that if his argument is correct, something may have been done differently with a permit after it was granted. If there's an issue with that, that's a matter for the code enforcement officer to resolve. And if there is dissatisfaction with the code enforcement officer's decision, that decision can be appealed. And that's what Mr. Slager is doing, is he's appealing that decision, but it's an enforcement matter. It's not a permit application matter. The only other thing I wanted to just mention, because I don't think anybody's touched on it, is that I believe technically the discussion we're having right now is on the appeal, the December 27th, 2019 appeal from Mr. Gilliam's December 3rd decision. And I'd just like to mention briefly, it's in my letter. I'm not going to say everything there is to say about it, but we think that that appeal is moot. I think everything else that's been said applies equally to both appeals. But on this one, there is the added issue of the fact that it's moot, because what Mr. Slager complained about in December was that Mr. Gilliam had not certified the reasons for lifting the suspension. Well, Mr. Gilliam reimposed the suspension in January, and then he certified his decision to lift it again in February. So there's really nothing left of that earlier appeal. And I think at this point, anything else I say will be repeating myself, and I'm going to try not to do that. So thank you for your time.
Thank you, Dan. Let's see if there's any questions for you. Jim, do you have any questions for Attorney Rosenthal?
No questions. Thank you.
April,
No questions.
Karen,
No questions.
Wayne,
No questions.
Gordon. That was a no. Kevin,
No questions.
and I have none either, so thank you, Dan.
Thank you.
If you, David, if you would put Dan back in the attendee. So now, all right, I guess we can do rebuttal at this time. Let's go to David first. David Laurie first. Hold on, David. Hold on. Okay, David. So this is some rebuttal time that we're being provided. You're being provided at this time. So
Understood, but I think it'd be more proper because Amy has given a statement, which I think she should finish up, and then I'll rebut them both at once. I think that'll be a better way to proceed. If you want me to, I'll go now. If you
go ahead and
insist.
go now, please.
You want me to go ahead? I will. And then Amy gets to rebut me again. All right. Section 2691 says, as Amy quoted and has in her memo, no board may assert jurisdiction over any matter unless the municipality has by charter or ordinance specified the purpose. That has to be read in pari materia along with section 4353, which says, in fact, that as to zoning matters go to the Board of Appeals. Section 4353 says the Board of Appeals shall hear appeals from any action or failure to act or board responsible for enforcing the zoning ordinance. Section 2691 deals with all other matters. The fire codes, things like that, can't be given to the Board of Appeals unless it's done expressly. As to zoning, that's already taken care of in 4353. And you have zoning jurisdiction over enforcement of the zoning ordinance unless the direct appeal to the Superior Court has been provided by municipal ordinance, which, as I said earlier, and I think that it's been pretty well conceded that it's not written into the statute that there is only a direct appeal to the Superior Court has been provided in the municipal ordinance, and that's undisputed. The operative statute here is 4353. Section 2691 applies to other areas of law, the fire code and things like that, saying that unless you have an ordinance or a charter provision, you don't get jurisdiction over those matters. But that's not zoning. This is a zoning dispute, or primarily a zoning dispute. There's also building code. But the law court has said when you're hearing a zoning code, a zoning dispute, and there's also a building code issue, you can hear them together. It's not wrong for you to hear them together. It's a law court decision, I believe I cited in my memorandum to you. If not, I can get it to you. But the bottom line is that you have jurisdiction here under 4353, and 2691 is in fact a red herring. The amendment, which was made in 2013 to 2693, was intended to deal with case law, which said the Superior Court has no jurisdiction to review ZBA decisions on enforcement because those are advisory only. And that's what the statute was directed to. Nothing to do with this situation. This situation is governed by 4353. And the bottom line is that you have jurisdiction under 4353. Section 9.2, I don't have any confusion. I said that at the beginning. And I don't know why Amy is saying that it's a question of confusion. It isn't a question of confusion. I said in my memo to you that there is an additional problem here of confusion of the public. I am not confused. I am very clear, I believe, that in fact, what is in section 9.2 does not meet the statutory requirement for for bypassing the board. And I hope I've been clear on that now, if I wasn't before.
Thank you. I'm just going to see, does anybody, Jim, do you have a question for?
No questions.
April?
You know, I do have a question. Mr. Laurie, why? Is there a reason you would rather have ZBA hear this appeal than Superior Court? I don't understand.
Actually, I personally would rather have the Superior Court hear it, but I think that the Superior Court's going to send it back to you, and then we're going to go around again in Superior Court after that, because the Superior Court doesn't want to hear it de novo. They don't want to hear it. But there's a public policy against direct appeals. They want to deal with a record. If it's an appeal, they want to have a record for that appeal when it comes to them. If you look at what there is right now, there's very little, because first off, the code officer said nothing about why he was lifting the stay. Then afterwards, he came back. Well, you don't want me to get into the merits, okay? No. But I'm just saying that the record before you at this time, it will review directly by the Superior Court. There's nothing in it, and the court wants to see a record developed by you, if that's at all possible. And under the statute, I don't think you have any choice under the statute. I would rather go to court myself, but unfortunately, I have a duty to present my client's case in a way where I won't have to be repeating it over and over again as it bounces back and forth between the Superior Court and you. I suspect that if you decline jurisdiction, I suspect the Superior Court's going to bounce it back to you anyway.
Okay, April?
Yeah, I'll give my reasons later.
Question, Karen?
No questions.
Wayne?
No questions.
Gordon?
Nope.
Kevin?
No questions.
I don't either. So thank you very much, David.
Okay, mute me.
Go back, and Amy, Amy, I'll wait till she's up.
We need to mute Gordon.
Amy, this is going to be your opportunity to offer rebuttal, brief rebuttal.
Thank you, Mr. Chairman, and thank you, members of the board. I'll be very brief. With respect to rebuttal, I do agree with Attorney Laurie that you do need to read section 2691 of the statute with 4353. Where we part ways is that I don't agree that 2691 is a red herring. 2691 is very clear, and I will not repeat what it says. But if you look at the language, it does require that the precise subject matter that may be appealed to the board must be stated. And I do think that's what 9.2A1 does. Furthermore, I'll just read you what Attorney Laurie has submitted to the court in his pleading to the Superior Court in his ADB appeal. He states, I quote, Kennebunkport Land Use Ordinance Article 9 specifically makes substantive appeals from the CEO's decision to lift the suspension order reviewable directly by the Superior Court pursuant to Rule 80B. So that is essentially what Attorney Laurie has already conceded and admitted. So I agree with him that it is clear, and he has said so before the court. My final point is just that I would like to underscore a point that Attorney Rosenthal made, and that is that my position is that the December 2019 appeal is moot and should be dismissed on that basis, along with the other arguments that jurisdictional arguments that I have made for both appeals. So I concur with Attorney Rosenthal that an additional ground to dismiss that one is that it is moot. Thank you.
Thank you. Any questions for Amy? Jim?
None, thank you.
April?
Nope.
Karen?
None.
Wayne?
None.
Gordon?
None.
Kevin?
No questions.
And none for me as well. Thank you, Amy. And if we could send Amy back and bring forward Dan. We bringing up Dan? Yeah, good. Dan, this is your rebuttal time. If you would be concise, that would be appreciated by the board.
Thank you very much. Very briefly, the ordinance is not confusing, and Mr. Laurie just said that he is not confused. We know he's not confused because he appealed to the Superior Court and he did it correctly. And Amy just read from his appeal to the Superior Court. So the idea of confusion, hypothetical confusion of someone else, I think is not a serious contention in light of how clear this ordinance is. In terms of what the Superior Court is likely to do with this appeal, we don't know, but I think we can have some confidence that what the Superior Court wants is to follow the law, follow the ordinance, apply it as it's written. And so that really comes first before anything else. And so that's my response to the suggestion that you're going to get this appeal back. I don't think that that is a reason to read this ordinance to say something other than what it says. So thank you again for your time.
Thank you. Any questions for Dan? Jim?
None, thank you.
April?
None.
Karen?
None.
Wayne?
None.
Gordon? Gordon?
Just had to unmute myself. I have no questions.
Thank you. Kevin?
None.
And I have none either. Thank you, Dan.
Thank you.
So now we have two really groups of people. I really can't tell by the names in the attendee section how to distinguish them, but I'll point out that the two groups are those that are immediate abutters that received an immediate abutters notice, and then those that are members of the general public. So I'm going to first ask if there are any folks that are in the that are out there that are listed as attendees, and that are abutters to the property and received an abutters notice that has either a question or wishes to make a statement, if you would indicate by clicking on that you want to raise your hand, I can recognize you. So I'll give you a few seconds to see if anybody fits into that category, if anybody's interested in speaking at this time. Give it an extra second, just in case the technology is challenging, and I know it has been for me. Okay, seeing none, then I'm going to move along to outside of the abutters. Now I'm going to see, is there anybody in the general public who is listed as an attendee that has a statement to make or a question with regard to the presentations? So if there's anybody that fits that description and wishes to be recognized, please electronically raise your hand. Okay, seeing none, then I'm going to at this time close the public hearing. So the public hearing, I'm sorry?
Could I ask Werner a question?
Yes, you can ask Warner a question. The board will ask that attendee Warner Gilliam be moved over to panelist. Warner, hi Warner. We're about to close the public hearing, but April would like to ask you a question.
Sure. Yep.
So I've been involved with the zoning board in one way or another, either as a member or as town clerk since 1997, which is over 20 years. And I don't ever remember the Superior Court sending something back to the board with regard to an enforcement issue, because the board didn't hear an enforcement issue because the ordinance says we're not supposed to. Do you recall ever the Superior Court sending something back to the board because of an enforcement issue?
No, I don't recall of any particular cases that we have had where there's been a remand regarding an enforcement action that has been sent back to the Zoning Board of Appeals. We have had remands that have come back to the Zoning Board, but those were not related to enforcement matters.
That's what I thought.
Okay.
Thank you.
Since Warner is here, before I formally close the public hearing, does anybody on the board have a question for Warner? Jim?
No questions.
Karen?
No questions.
Wayne?
Would you like to add anything, Warner?
No, I don't have anything in particular to add. I believe Amy Chow has represented my position accurately.
Thank you. Gordon?
No questions.
Kevin?
None.
Any more, April?
Nope, I'm good.
I'm good too. Thank you, Warner. So at this time, I'm going to close the public hearing. And now we can all be live and in color. I'm going to go to each one of you one at a time to start our deliberation with regard to the question at hand. I'm going to note before we do that, that I'm sure, depending on the result of this hearing, whichever way it goes, we still have a second hearing to go through that I'm going to attempt to abbreviate based on all the presentations that we've heard so far, because the arguments are with regard to both for the most part, but we'll give council the opportunity to address it again when we move into the second item on the agenda. But this is the first item on the agenda. So as to the discussions that we've heard with regard to the appeal that was filed on December 27th, 2019, which is really the second appeal filed by Mr. Slager. But the first of the two we're hearing tonight. I'm going to go to each one of you one at a time. Let's hear your thoughts at this time on this matter of, does the board have jurisdiction to hear this appeal? First, Jim, I'm going to go to you.
I believe that David Laurie, Attorney Laurie, really has not made any significant change to my thinking about whether or not this appeal should be heard. So I'm really, I'm at a point where I don't believe we should accept this appeal.
Okay. Karen, what are your thoughts?
Me? I do have a question. Where they have already filed with Superior Court, could there be a conflict where now he's having two appeals at the same time being heard?
I don't, well, we don't really need to go there, but my guess would be no. He filed in both jurisdictions or both forums to preserve rights in both.
Okay.
So, and if this board decided that we do have jurisdiction to hear this appeal, then I would presume that Attorney Laurie will file on the scheduling order that gets imposed when you file an 80B appeal. And I would assume the court would grant that, and I would assume that Attorneys Chow and Rosenthal would go along with that request for stay, and then it would move along that way. So I don't personally, I don't find that to be problematic. I've done it before, so I don't find it problematic.
So in reading the ordinance, I am still stuck on what it says to us, and I do not feel as though this is something to be heard in front of our board on an enforcement matter.
Okay, and are you basing your thoughts mostly on the reading of the statute? I'm sorry, the reading of the ordinance?
Our ordinance.
All right, I'm going to go back to Jim for 1 minute. Jim, is
Yeah.
your reasoning primarily, what is your reasoning based on where you're leaning that there is no, that this doesn't have jurisdiction? What are you basing that on for the most part?
Mostly on the ordinance.
Mostly on the ordinance. Okay. Wayne, can you share us your thoughts on whether this board has jurisdiction to hear this pending appeal?
I will. So far, and there appears to be no strong issue of that it is not, or let me put this in a positive, it is an enforcement related matter. And so the arguments on both sides seem to be related to that. And I'm going back to our ordinance as well, and which is why I asked Amy the question on 9.22, where the board shall interpret the ordinance. And that does not say, or I'm not comfortable with it then saying, then let's interpret the statute as well. Now, I find it in two different places where we are restricted. It's in 9.2A1, where it has been pointed out that, that we don't have jurisdiction over enforcement of the ordinance. And if you go to, of course, we've been throwing around a lot of numbers tonight, under the appeals procedure for this board, so 9.3AB, it brings up the same issue. Other than a decision or failure to act related to an enforcement related matter. So it is in our ordinance, it's in there twice. So it's very clear that we don't have decision-making process over that.
Okay, thank you. Gordon? You're muted, Gordon. Gordon?
I have nothing to add. Thank you.
Thank you. Kevin?
So I thought our ordinance was pretty clear, the plain language piece of it, that, only permit application type of items falls under our purview for this. And when I read, 4353, seems pretty clear to me there as well. And 4353 actually says, that we're governed by 2691. And if you look at 2691, I think 2691 also is pretty clear that the language in our ordinance, spells out what we can and can't do. And so from my point of view, it's pretty clear.
Okay.
That's it.
April?
I'm pretty clear on this. I believe state law gives us our jurisdiction, but the ordinance tells us what we can and can't do. The voters of Kennebunkport told us what we can and can't do by adopting this ordinance. And it's very clear in the ordinance, any notice of violation, which is what Werner issued, is not appealable to the Board of Appeals. We can't hear this. I believe we can't hear this. I don't think that the court has ever had a problem with our ordinance, saying that our ordinance is too vague or what have you. I think the ordinance is pretty clear. We've never had an issue. The court's never sent anything back to us because the ordinance is vague or not well written or what have you. So I'm pretty clear that we don't have the right. I can't even imagine if we did have the right to hear enforcement issues. We're not qualified. Certainly, we don't have any code enforcement training. Code enforcement officers, they go to all kinds of classes and have to pass tests and meet certifications. We don't have any clue as to what the codes say. We only can interpret this ordinance. And my interpretation of the ordinance is we don't have the right to hear an appeal about an enforcement issue.
Okay. The only thing that I'd add, I guess, because I kind of agree with everything that everybody said, but it was a point that I kind of was trying to make and that Attorney Rosenthal echoed. And I think that section 92A1 gives you a direct line to Superior Court. I'm not saying that it has to, but I believe that when it says such enforcement actions are appealable only to the courts as allowed by law and the rules of civil procedure. And when you go to the rules of civil procedure and you want to appeal a decision of a municipal decision, that comes under my recollection, though I didn't go back and read it, Rule 80B, and Rule 80B is for procedure in Superior Court. So I think it is somewhat of a straight line to Superior Court. It's not as explicit as Attorney Laurie was arguing, but I don't think it needs to be, as was noted or argued by Attorney Chow and Attorney Rosenthal. Does anybody on the board have a need to ask a question of anybody that's made any of the three presentations this evening?
Nope.
Okay, I see shaking heads, but I'll just go quickly. Jim?
No.
Karen?
No.
Wayne?
No.
Gordon?
No.
Thank you. Kevin?
Nope.
April?
No.
No, and I don't as well. I think that we're coming to the point where we can entertain a motion. Now, in a minute, I'm going to ask for a motion, and then I'll ask for a second. And then when we take a vote on the motion, I'll go to each one of you individually for your vote at that time. And I'm asking for a motion, just for clarity. I think I'd like the motion to be made in the affirmative, which is to say that I think the motion should be fashioned. Do we have jurisdiction? It doesn't have to be these words, but do we have jurisdiction to hear this pending appeal? So can someone out there on the board make a motion?
Who can articulate that?
I have too many muted microphones. Well, if we don't have a motion, I guess we're kind of frozen.
I'll make a motion.
Thank you.
I've just got to pull up the, hold on, I'm just pulling up the agenda. Right. You want it in the affirmative. I make a motion that the Zoning Board of Appeals does not have the jurisdiction to hear the appeal of Randy Slager, the application that was submitted on December 27th, 2019.
Well, that wasn't a negative, but that's okay.
Oh, sorry.
The opposite of what I was asking for, but it came out beautifully. So do I hear a second of that motion?
I'll second.
Thank you. All right, so now we have a pending motion, and the motion is, Karen, did you get that motion down?
Yeah.
Why don't
That
you
zoning board of appeals does not have jurisdiction to hear the appeal of Randy Slager, an application submitted 12/27/2019.
Okay, so that if you vote either yay or nay, actually, let's make it yes or no, because that's a little clearer. If you vote yes, then you're agreeing the board has no jurisdiction. And if you vote no, you're saying that the board does have jurisdiction. So yes is no jurisdiction, and no is we have jurisdiction. Okay. Now I've muddied that water a little bit. You can see I want it in the affirmative. Jim?
Yes.
Vote yes, one vote yes, we have no jurisdiction. Karen?
Yes.
Wayne?
Yes.
Gordon?
Yes.
Kevin?
Yes.
April?
Yes.
And the chair votes yes. So by a vote of 7-0, the motion passes, and the board has decided that it does not have jurisdiction to hear the appeal of Randy Slager submitted on December 27th, 2019. Thank you for that. So now we're going to move into the second item on the agenda. I'm going to try to abbreviate it as we move. So everybody is familiar with the format. I'm not going to review what the format was because we just ran through it. I will read item 2 on our agenda. Randy Slager, applicant, submission dated March 25, 2020. The applicant is appealing the lifting of suspension of permit without all corrective measures ordered being taken. This regards 200 Ocean Avenue, tax map 7, block 12, lot 5 in the Cape Arundel zone. This hearing is to determine if this board has jurisdiction to hear this appeal under our land use ordinance section 92A1 and 2. So I want to make echo a note that I stated before, that pursuant to our ordinance, an appeal when filed is to be heard in 35 days. Unless that date is extended, by agreement of the parties, and the parties to this appeal all agreed to the extension of the date, which brings us to today. So that said, first I'm going to ask David and Michelle if you would move Attorney Laurie from attendee up to panelist. So Attorney Laurie, we're moving on to the second item, and that's the appeal that was filed on March 25, 2020. And we're aware of all arguments that you have made first time around. I thought we needed to separate these because they were two separate appeals. This is your opportunity, if you wish, to add anything with regard to our review of the jurisdictional matter with regard to this second appeal. If you want to, you can simply say you just reiterate everything you've said before, but you're a lawyer, so I know you might want to say something.
Well, the comments by the various members of the board were all over the place for different reasons, but most of you appear to have relied on the ordinance. And as I said before, the ordinance doesn't apply because the ordinance doesn't comply with section 4353. Section 2691 is a red herring. It has absolutely nothing to do with with your jurisdiction over a zoning appeal. The statute's very clear. It says the Board of Appeals shall hear appeals from any action or failure to act of an official or board responsible for enforcing the zoning ordinance. 2691 does not apply. And neither does your ordinance because you didn't provide, because it doesn't provide a direct appeal by municipal ordinance. And it's very clear under the statute. What the court's going to do with it, I don't know. I don't know whether I want to have it remanded back to you, but I suspect that I will ask that of the court. In any case, the bottom line is that you're required to hear this appeal. And I have a declaratory judgment that was filed along with the ADB appeal, a declaratory judgment to decide what your jurisdiction is over these matters. And we'll probably press on with that regardless. Thank you.
Okay, any questions for Attorney Rosenthal? Sorry, Attorney Lowry. Jim?
None.
Karen?
None.
Wayne?
None.
Gordon?
None.
Kevin?
Nope, none.
April?
None.
I'm just going to ask one question, Attorney Rosenthal. So we do, under our ordinance, have under section 9(2)(a)(2), we are empowered to interpret the provisions of our ordinance. And you're suggesting that we determine that the provisions of our ordinance fail to comply with state statute, and therefore we should interpret state statute as directing us to take on this appeal?
What I'm saying is that you don't have to interpret the state statute at all. It's very clear. It says in one sentence, the board shall have appeals, shall hear. You're supposed to hear. It says shall. It's required to hear appeals from any action or failure to act of the official or board responsible for enforcing the zoning ordinance. Why I'm saying 2691 has nothing to do with this appeal. And I'm also saying that it says, unless a direct appeal to the Superior Court has been provided by municipal ordinance. Well, it hasn't. The municipal ordinance only tolerates appeals that may be made under ADB or, well, they got to be under ADB if they're going to happen at all. But the bottom line is that the statute's very clear that you have jurisdiction over this matter. And it's not, and you never actually get into the ordinance itself. And what can I say? I mean, I don't want to belabor the point.
Okay, thank you. All right, then you can have Attorney Lori go back into the attendees, and let's bring up Attorney Chow, please. Hi, Attorney Chow. Do you have anything that you wish to add that differs from your argument before? Do you want to just reiterate everything that you've said before? Do you have anything additional you'd like to add? Just something, this is your opportunity.
Thank you very much, Mr. Chairman. I'm mindful of the time and I don't have anything substantive to add. I would reiterate all the same arguments that I made, and I disagree strongly with Mr. Laurie that 2691 is a red herring. I think it needs to be interpreted. Actually, he admitted that 2691 and 4353 need to be read together. And when you read them together, it's clear that you have to be specific about the precise subject matter over which you have jurisdiction. So I won't belabor that point. The final point I would like to make is I actually felt that each and every board member's comments were coherent and very cogent and not all over the place. Thank you.
Thank you. Any questions for Attorney Chow? Jim?
No question.
Darren?
No questions.
Wayne?
No questions.
Gordon?
No questions.
Kevin?
No questions.
April?
No questions.
I have no questions. Thank you, Attorney Chow. And if Attorney Chow could be sent back to the attendees area, and if we could bring forward Attorney Rosenthal. Attorney Rosenthal, this is going to be your opportunity to expound on the issue of jurisdiction with regard to the second appeal. If you wish, you can just simply reiterate all that which you offered under the first appeal, or you can add more, or you can respond to what either Attorney Laurie or Chow had said. Do you have anything to offer?
I'll reiterate what I said before with respect to the other appeal, and I will also just add that I think the board members' deliberations reflect that they considered the parties' written submissions and their arguments and based their decisions tonight on the ordinance. And we thank you again for your time.
Thank you. Any questions for Attorney Rosenthal? Jim?
None.
Darren?
No questions.
Wayne?
No questions.
Gordon, your mic's off. Gordon?
No questions.
Kevin?
No questions.
April?
No questions.
And I have no questions. Thank you, Attorney Rosenthal.
Thank you.
So rather than, and if Attorney Rosenthal could go back into the attendees area, I would, this would be a time when any of the three parties, attorneys, can offer a rebuttal. So rather than bring up each, I'll wait till Dan gets back into the attendee place. If any of the three attorneys, being Attorney Lowry, Attorney Chow, and Attorney Rosenthal, have any rebuttal to offer with regard to this second appeal, why don't you just, instead of me bringing each one of you up, if you could just, I'll give you a minute to raise your hand. And your opportunity, if you'd like to offer rebuttal, please raise your hand, your electronic hand, and I'll give a few seconds for that to happen. And seeing none, then I'm going to say that no attorney has opted to offer any rebuttal. And I'm going to again ask if there is any abutter, that any individual out there who's participating as attendee who received the notice as an abutter, who wishes to make a statement or offer a position or ask a question, please so indicate by raising your electronic hand, and I'll give a few seconds for that. Seeing none, I will move along to members of the general public. Are there any members of the general public that wish to make a statement for a position or ask a question with regard to this second appeal? If you do, please raise your electronic hand. We'll give a couple of seconds for that to occur. Seeing none, I'm going to, at this time, close the public hearing and open the debate with regard to if the question is, does this board have jurisdiction to hear this, what I've identified as the second appeal, which is the appeal of Randy Slager that was submitted on March 25, 2020. I'm going to go to each of you and I would ask that instead of saying that you don't have anything to say, if you could indicate the direction that you're thinking, and if you wish to just say that if you don't want to for anything, and what you have to say would be the same as what you've said before, then so indicate by saying you'd like to just reiterate the comments you made before. So I'll begin with Jim.
I would say I see no change between the two appeals, and I offer the same arguments that I gave the first time in the first appeal.
Thank you. Karen,
I feel the same. Nothing new to add.
do you reiterate what you offered before?
Yes.
Wayne?
I also agree, and I reiterate my comments from appeal number 1.
Thank you. Gordon?
I reluctantly have to agree. I will say that the case number 2 points out the deficiencies, that there should be an opportunity to appeal under those circumstances. But the law is they don't have the opportunity to appeal.
When you say they don't have the opportunity to appeal, they do have the opportunity to appeal, just not necessarily to this board. They still have the right to appeal, which indeed they've
Oh,
exercised.
of course.
Okay, just wanted to clarify that a bit. Anything else, Gordon?
No.
Kevin?
No change in my comments from last time.
So you reiterate them?
I reiterate.
Thank you. April?
I reiterate what I said last time.
Thank you. And same goes for me. I reiterate that which I offered before. Does the board need any further discussion on this second appeal? Okay.
No.
See, no indication from anybody that anybody needs anything additional. Then I think that I would ask if I could have a motion. It'd be cool if it was in the affirmative, but it doesn't have to be in the affirmative. The negative works perfectly well. Can I have a motion?
Do you want me to make the motion again?
I'd
It's
love
going to
it.
be the same.
Yeah, no. Just make a motion. You did very well the last time. I'm just fooling around with it.
So I make a motion that the zoning board of appeals does not have the jurisdiction to hear the application received by Randy Slager, submitted March 25th, 2020.
Thank you. Do I have a second?
I'll second that.
Okay, we have a second. Karen, you're getting all this down?
With my scribbles, but yep.
Thank you. So now we'll vote. So just to state again, vote. What? No, read the motion back, Karen, or
Okay, dated. Zoning Board of Appeals does not have jurisdiction to hear application received by Randy Slager dated March 25th, 2020.
Okay, so a vote in the affirmative is that we do not have jurisdiction, and a vote in the negative is that we do have jurisdiction. Affirmative, no jurisdiction, negative, jurisdiction. James,
Affirmative.
Karen,
Affirmative.
Wayne,
Yes.
Gordon,
No,
Kevin,
Yes,
April,
Yes.
and the chair votes yes, so the vote is 6 in the affirmative and 1 in the negative, 1 opposed. So the motion passes. And the board holds that it does not have jurisdiction to entertain the second appeal. So that, I believe, is the conclusion of our hearing. I want to thank everybody for really cooperating and making this move pretty good. We got it done in 2 hours and 6 minutes. Congratulations to everybody. Thank you for your participation. Wayne, thank you for coming back from wherever you were and showing up. Gordon, thanks very much. Good to see you again, Gordon. We appreciate you being
nice to see you too.
Everybody else, thank you so much. That concludes the hearing. I'm going to entertain a motion to close the public hearing. Do I have a motion?
I
So
make a
moved.
motion.
A second?
second.
All in favor? Oh, I can't do it that way. Jake,
We're really making a motion to adjourn.
we're making a
Yes.
motion to adjourn. If you're in favor, we're adjourning. James,
Yes.
Karen,
Yes.
Wayne,
Yes.
Gordon,
Yes.
Kevin,
Yes.
April.
Yes.
And the chair votes affirmative as well. So this meeting is now adjourned. Thanks, everybody.
Hey, everybody, just check your email for the minutes and we'll review them for next meeting.
Okay.